Good morning, and thank you all for being here today. I here am a lawyer in copyright media, and I'm here to talk to all of you about copyright law and some changes that need to be made in policy. Copyright law, due to its laxness, has often been abused and exploited in Hollywood in the United States, often by bigger corporations exploiting small corporations and individuals. This is something we should be enraged about. According to the books, technically, all intellectual property is automatically copyrighted. In reality, this is not so, and does not protect your work from being stolen. Not having a work registered with copyright severely limits the creator's legal rights. According to Section 411A of the United States Copyright Act, you cannot sue for copyright infringement if the work is not registered with the Copyright Office. For example, according to the website of the United States Copyright Office, a defendant can only file a lawsuit if the work has been plagiarized, only provided that the infringement began after the effective date of registration. This means that you cannot sue if your work has been stolen unless you have copyrighted it ahead of time, before someone stole your work. I believe you shouldn't have to pay for something to be intellectual property. According to the Copyright Alliance organization, a non-refundable filing fee has to be filed and registered a copyright, which can be up to $140 depending on the kind of work it is. According to lawyer Aaron Hall, if you register a copyright in a hurry so you can launch legal action, the current fee is about $685, and a high chance that you won't get it if the copyright is filed after the infringement began. And the filing fee doesn't even guarantee that the copyright goes through, but it's non-refundable. In fact, according to Section 412 of the United States Copyright Law, no award of statutory damages or attorney's fees shall be made for any infringement of copyright in unpublished work commenced before the effective date of registration, or any infringement of copyright commenced after the first publication of the work and before the effective date of registration, unless such registration is made within 3 months of the first publication of the work. And without the ability to claim statutory damages, it's almost impossible to file a lawsuit. Plus, it doesn't make sense to sue. Plenty of properties and intellectual works have been hurt by this copyright law. For example, the famous movie and franchise we all know, Night of the Living Dead, by the Walter Reed organization, became public domain because the film was not registered in time. Another copyright law, which is extremely lax and needs to be stricter, is the one that says you cannot copyright ideas, only expression of ideas. There are very famous lawsuits lost because of this. For example, as we all know, the movie Zootopia. But did you know that it was made by a smaller company, not known as Esplanade Productions, not Disney, who pitched the idea of a movie similar to Zootopia, the exact same character designs, themes, settings, and titles? Although Disney rejected the pitch at first, twice, they copied all of those aspects in the movie Zootopia, but in court, because there lacked copyright laws, it was stated the similarity was too general to be protected by copyright law. But it only gets worse from here. Many movies and studios have admitted to stealing their ideas, but because the work wasn't protected by copyright, the prosecutor couldn't take any legal action against the defendants. This all started in 1956 with Disney versus Wilder. Wilder stole a movie idea from Disney, but the court ruled in favor of Wilder because there was no written contract. Because according to the court, this is an exact quote, "The idea man who blurts out his idea without first having made his bargain has no one to blame but himself for the loss of his bargaining power." Which means that unless an official contract, not an implied contract, is stated in advance, copyright law states that you can take anybody's ideas as long as it's not registered. In that case, Disney versus Wilder has been used as precedent in many copyright cases, especially for Hollywood and screenwriting today. For example, you may have all heard of the movie and the franchise The Purge. But have you heard of Jordan Bennell versus University City Studios in 2017? This information is from the Cohen Debates Abrahams and Shepard's Law website, by the way. Do you know that The Purge was stolen from Jordan Peele's Settlers Day movie, which was rejected twice by Universal for being unrealistic? In court, however, they admitted that it was stolen, but claimed there was no written contract saying they had to pay for Jordan Peele's idea, so it was okay. And they used Disney versus Wilder as precedent. This happens all the time in Hollywood. According to an article on NBC News, Hollywood's new piracy problem, attorney John Martyr from the LA firm Manning and Martyr said, "They simply exclude the writer, the person that brought them this valuable property, and develop it themselves and hide behind copyright," when referring to Hollywood producers. He adds, "They say, hey, your ideas weren't protected. Whether we stole them or not, you have no claim." There are countless incidences, you guys can look it up yourself, similar to The Purge and Zootopia, whereas bigger companies like Disney and Universal have taken ideas from smaller writers. Many have even admitted to it, but said that due to the fact that it was not registered and there was no official contract signed, it was legal. So clearly, copyright laws need to be stricter. If you want a community not just ruled by select monopolies such as Disney, where people's ideas can be expressed, we must have stricter copyright laws, especially in Hollywood. Thank you.